Hi, my name is Andrea McGinn.
My name is Tara Elcock, and we are both attorneys at the Law Shop at Iowa over in Van Meter. We have a combined over 3 decades of experience, almost exclusively in the areas of family and child welfare law. We have a passion for working with children and families, and our favorite clients are when we get to represent children.
When a couple with children decides to separate, they have to come up with a plan on when the kiddos will be at each household and how the parents are going to make decisions about the children's education, medical care, and so on. Sometimes when a couple separates, they decide or the court decides that there needs to be someone else to come in and represent the child's interest in some form. So Tara and I are going to talk today about what options separating couples have to represent the interests of the child. One option is a child's attorney. A child's attorney would be appointed by the court after one or both of the parents ask the court to appoint an attorney for the child. That attorney would then represent what the child wants, just like an attorney for the other parties, representing the interests or desires of that party. The attorney is a party to the proceeding and are bound to attorney confidentiality rules, and privilege applies between them and their client. They present evidence and argue for the child's wishes. A custody evaluator is another option and is usually a licensed mental health professional that has specific training in conducting child custody evaluations. The process can vary depending on the individual conducting the evaluation, but usually consists of individual sessions with each parent and sessions observing the parents with the children. The evaluator usually issues a report. A guardian ad litem, or GAL, is another option for child representation and is an attorney appointed by the court to represent the best interests of the child. The guardian ad litem is a party to the proceeding, meaning that they can present their own evidence, file exhibits, present witnesses and testimony, and argue for what is in the best interest of the child. They would appear at mediations for the case and would conduct their own investigation by speaking with each of the parents, collateral sources identified by the parents, and speaking with providers for the child, like teachers, daycare providers, therapists, so on. They then advocate for their position on what is in the best interest of the child as far as custody goes and what a schedule could look like between the parents.
A fourth option is a child and family reporter, also known as a CFR. This person is not necessarily an attorney. They could also be a mental health professional or a person the court appoints that is qualified for the role. But in our experience, pretty much always is an attorney with family law experience, specifically in representing children. This is someone appointed by the court to also represent the best interest of the child. However, they are not a party to the proceeding. They are more of a neutral third-party reporter that conducts an independent investigation like the guardian ad litem will do, but their job is not to take a position and argue or present evidence for what's in the best interest of the child. However, they will issue a report. The report will contain facts and observations made during their investigation, as well as recommendations as to what they believe would be in the best interest of the child for a schedule and decision-making rights and responsibilities and other identified issues between the parents. Those recommendations, however, are only allowed if the court orders the CFR to make recommendations. Otherwise, the report is solely a report of the investigation and observations made during the investigation. The report is done usually in anticipation of trial. However, sometimes there isn't an actual formal report done, as the CFR will often, more informally after their investigation, discuss with the parents and their lawyers what their observations were and what their recommendations will likely be if they were to draft that final report. The role of the CFR is an objective and even-handed reporter, tasked with gathering factual information that will assist the court and parties to make decisions related to the welfare of the child. The purpose of the CFR is to promote respect for the rights of the parties and their children and to improve outcomes for the children. So who pays for these services? It is also governed by the court, but often it is split amongst the parties.
All of these options for child representation are aimed at aiding in reaching a settlement between the parents. Parents know their child and their family the best, and so these roles help them keep the child's desires or best interests at the forefront of any custody dispute. Having a third party discuss with the parents their perspective or position on behalf of the child or the child's best interest aids the parties in maintaining control over the welfare of their children and keeping it out of a courtroom. If you're ever involved in a child custody action, inquire with your lawyer about the options for child representation. Tara and I are accepting appointments as child's attorney, guardian ad litem, or child and family reporter, and would be honored to help you and your children navigate your separation and ensure the best outcome for all involved.